previous events. So it's great to be back. And today we've got the glamorous job of talking about IR35, which isn't necessarily one of the most exciting of topics, but we'll try and make it as engaging and exciting as it possibly can be. That was a great introduction, so covered a lot of what I was going to say initially anyway. So really, in terms of IR35, what we're both going to be looking at today, so Tom and I, who we both work at the Lincoln office of Wilkin Chapman, we're going to be covering, well, who is actually affected and impacted by IR35 and the off-payroll worker rules. We're going to be looking at and discussing, well, how are those rules applied, the steps that need to be taken to really ensure compliance and you're doing everything that you need to be doing, considering and looking at, or your clients need to be looking at, and really what steps should people be taking now with that in mind. So as you all know, IR35 is not new. It's actually been around for about 17 years. And the reason that it was introduced initially by HMRC was that they considered that they were missing out a lot in terms of tax. So the coffers could have been a lot more full for tax and national insurance. And really, they looked at ways in which they could target individuals who they believe should have been taxed as employees. So they're looking at contractors, consultants, but were actually delivering their services through a personal service company, so a PSC, which we'll go through quite a lot today. So initially and historically, it's been the intermediary, so the personal service company, that themselves had to determine, well, what tax and national insurance should I be paying? And inevitably, the estimates from HMRC were that probably 90% of those intermediaries were in fact, unsurprisingly, not paying the correct amount of tax and national insurance, and were paying themselves through dividends because of the tax advantages to that. So really the focus of today is the off-payroll worker rules, IR35, and they were introduced into the public sector initially back in 2017. They were due to come in last year, but because of coronavirus, it was delayed until April this year. Probably one advantage of that 1 year delay is that it's actually given people a bit more time to consider what they should be doing. Not only the larger companies, the end users that engage with consultants and professional service companies, but also the professional service companies themselves to get the house in order and really consider their relationships, their tax implications, and probably get some advice during this 1 year period as well. So we deal with a lot of people. We get a lot of requests for advice on whether IR35 applies to their situation. What should they be doing? So we'll really give you some tips on what we advise clients throughout the course of today. So myself and Tom are going to share what we're going to go through to split it up and hopefully keep it flowing. So I'm going to pass you over to Tom to really discuss and go through that first area of who are these rules going to impact. So over to you, Tom.
Thanks, Oliver, and good morning, everyone. Hope you're all doing well. Thanks for joining us. So yeah, as Oliver said, what I'm going to just briefly touch on, first of all, is when do these rules apply? So as Oliver sort of briefly hinted at, the main things that you need to be looking at to determine whether or not you are within the scope of these rules, there are three things. What you're looking for is an individual who is providing services to an end user client, and they provide those services through an intermediary. So that is often a personal service company or PSC, or sometimes can be a partnership as well. But what you're generally looking at is a situation where you've got Joe Bloggs providing services to, say, Wilkin Chapman as the end user client, and Wilkin Chapman contracts and is invoiced by Joe Bloggs Limited, which is the individual's own personal service company. So there might be a number of other entities in that chain. So you might find that there are some agencies that act as sort of middlemen between the end user and the personal service company, for example. But when you're looking at the test and to see if whether or not these rules apply, is those three initial factors that you're looking at. So any supply chain that includes an individual, a personal service company, and the end user client, that, generally speaking, is going to be caught by these new off-payroll working rules. Now, there are a couple of exceptions to that general rule, and I'll go through both of those in turn now. So the first of those is the small company exemption. So where the end user client is a small company, they are exempt from the off-payroll working rules, and the supply chain won't have to consider them. What do I mean by a small company? Well, we use the Companies Act definition of small, and you are a small company if you satisfy two of the following three criteria. So you have less than 50 employees, less than £10.2 million of turnover in the last financial year, and less than £5.1 million on the balance sheet in the last financial year. So if the end user in the supply chain satisfies two or more of those three criteria, they are a small company and they are exempt from the off-payroll working rules. If you are a group company, or the end user is part of a group, when you're looking at that small company test, you apply that to the holding company in the group. If the holding company is small, the rules don't apply. If the holding company is a medium or large entity, then the rules will apply regardless of the size of the actual end user client in the chain. Just a note on that as well, that if the individual asks you to provide information to them as the end user about the size of your company, you are obliged to tell them whether or not you are small, medium, or large. So that's the first exemption. The second exemption is where the end user client doesn't have a UK connection. So if they don't have a UK connection, again, the rules won't apply. So what do I mean by UK connection? Well, that can be one of two things. So the end user can either be a resident of the UK, meaning that it's either incorporated, managed, or controlled within the UK, or it has to have a permanent establishment in the UK, so a fixed place of business through which they trade. So if the end user client in your supply chain has one of those two things, so is either a UK resident or has a permanent UK establishment, then the rules will be applicable to that supply chain. However, if there's no UK connection, then the rules don't apply. I think we've got a question come through on the chat.
We've got a couple there, Tom.
Yeah, does the small company test regarding the number of employees exclude employees based overseas? I'd have to get back to you on that one, to be honest. I don't know, Oliver, whether that's something you've come across before, but I would imagine that it is the number of employees that are employed by that entity, whether they are based overseas or not.
Yeah, that's right, Tom. Yeah, that's correct. So it's employed by that entity. So if they're on your payroll, you're paying employers' national insurance and they're taxed as if they're in the UK, then yes, they would apply.
Excellent. Thank you, Oliver. And yeah, so that's it from me for that section. So what we're going to look at for the rest of the webinar is a situation where those rules do apply. So I'll pass you back to Oliver now to talk through what the two main issues are to consider if those rules do apply to your supply chain.
Yeah, so the two main, or the two key responsibilities that you need to be considering if the rules do apply to the situation and circumstance is firstly status determination, and Tom's going to go through that in a bit more detail shortly. So who's responsible for determining the status of the relationship and the rules apply, etc., really, and the status of the individual. Secondly, is about the fee payer obligation. So who is actually going to be paying the tax and national insurance? So Tom's just going to bring up a slide now so that we can visualize it and see it, which makes it a lot easier. So on the left-hand side, here we've got where the end user, so the person that's actually receiving the services, is a small company. So just what Tom's explained in terms of what a small company, small entity is. So both the responsibility in this chain in terms of determining the status, and actually the fee payer responsibilities fall on the PSC. So that reflects what the traditional relationship was, and that's reflects really how it was way back when it was introduced back in 17 years ago and onwards, so in line with the original IR35 rules. Now on the right hand side, we've got two circumstances there. So as you'll see, under the new off-payroll worker rules, the status determination obligation always falls on the end user. So the entity that is actually receiving the services, the end user, they will always be obliged and they will always have to carry out the status determination. And again, we'll go through what that exactly means later on. And that's no matter how many people are in that supply chain. So we've got a typical supply chain on the left-hand side where it's the worker, the professional services, personal services company, and then the end user. And then the one on the right-hand side of the screen is where an agency is involved as well. The fee payer responsibility, so who's paying the tax and national insurance, that will always fall on the organisation that sits in the chain directly above the personal service company. So as we see on the right hand side, we've got the agency, so they will be obliged to pay the tax and national insurance. On the left hand side, it is and falls upon the end user client. So if we have a look on the next slide, what this will show is that, or the complication that may arise if you have lots of different entities and organizations within that chain. Now, if the original fee payer liability, so here, agency number 2 sits above the personal service company, they are the ones that are obliged to pay the fee in the chain. Now, if they don't pay the fee or they don't have the means to pay the fee, what HMRC can do is go back up the chain, so you can see the arrows there, until they get to an entity that can pay the fee. So technically, you as the end user client could still be liable for the fee payer responsibilities if those agencies or otherwise in the chain don't pay. So the liability can actually pass. So that probably highlights the importance that if you are involved in a chain, if there are agencies, there's umbrella companies, whatever that may be, probably do your due diligence about them, do a search about them, go on the company's house, basically make sure that they are a solvent trading entity, a decent or good balance sheet that will be able to pay that fee payer responsibility. So protect yourself by just doing some due diligence and background checks upon that entity. So Tom, can you just go through and explain the first key responsibility of the status determination aspect?
Absolutely. So status determination, as Oliver said, is always the responsibility of the end user client receiving those services. And so what they have to determine is the employment status for tax purposes of the individual who is providing them with those services. So what we're looking at in that case is whether or not there is what's called deemed employment. So what that means is whether there would be an employment relationship between the individual and the end user client if it weren't for the intermediary, the PSC, sitting in the middle of those two. So if you took the PSC out of it, would there be an employment relationship between the individual and the end user, or would it just be a genuinely self-employed relationship? So what I must stress at this point in time is that this is purely, what we're looking at today is purely an employment status test for tax purposes. This is different in some ways to looking at the employment status test for employment rights. So for example, the right to holiday pay, the right to bring a claim for unfair dismissal, for example. So all we're looking at here is how to determine someone's tax liability in the situation where we have one of these supply chains. Their employment status for other rights is something that we could spend a whole nother webinar talking about. You'll see though, however, if you're familiar with those sorts of tests, that they are very similar. So what are those tests in the tax arena? Well, the first things that you are going to need to look at are what we call the 3 pillars. So 3 main things that you need to focus on when you're analysing the relationship with these individuals. The first is personal service. So is this individual under an obligation to provide the services to the end user personally? Does that end user require only that individual? Or alternatively, can that individual send a substitute in their place to do the work if for whatever reason they can't do it? If there is a requirement of personal service, that is something that is a strong indicator of deemed employment, and something that will therefore bring with it the new off-payroll working rules. However, if there is an unfettered right of substitution, i.e. the individual can send whoever they like to come and provide those services, as long as those services get provided, then that's something that will indicate the other way, i.e. that the arrangement is outside the scope of the off-payroll working rules. In terms of that right of substitution, a couple of things just to note. So the first is that any employment tribunal or court will look beyond merely having a term in the contract. So if you contract with the personal service company and there is a term in there that says that they can send a substitute, that's all well and good, and it is certainly something that we would advise you have in that contract. But if it's never used, or if the end user client constantly refuses to accept a substitute, then again, that's not going to play well before a tribunal, and they're going to look more towards that being a situation of deemed employment. And also, the more caveats you put in that right of substitution, the more, again, that's going to lead towards deemed employment. Save perhaps for one, I would say that obviously it goes without saying really that you have to have someone provide the services who is suitably qualified and has the relevant skills to do that. What you don't want is me being sent as a substitute to a power station and then just dropping the entire national grid down because I haven't got a clue what I'm doing. So I think you are well within your rights to say that if you are going to send a substitute, it has to be someone who has the requisite skills to be able to perform the services. So I think that's fine. Any more caveats that you put on that right of substitution, you're going to be moving more towards a situation of deemed employment with that. So that's the first pillar. The second pillar is mutuality of obligation. Now, this is a relatively murky area in employment law. It's quite a grey one, but I'll do my best to explain it in its simplest form. It just requires you to ask 2 questions. Is the end user client obliged to provide the individual with work? And if the answer to that is yes, is that individual then required to provide the work if they are asked to do it? So if there is no obligation on either side to either provide work or to carry out work, then you are looking at a genuine self-employed relationship. If there is an obligation on both sides to provide work and to carry out the work, then you have mutuality of obligation there. And again, you are probably looking at a situation that is going to be strongly suggested as deemed employment. Now, it's not always that straightforward to figure out, and employment lawyers have been struggling with mutuality of obligation, as have tribunals, for quite some time, and it is still a fairly grey area. And Oliver, I think, is going to touch a bit later on HMRC's view on mutuality of obligation when he talks through the CES tool with you, so I won't dig too deep into that now. But that is the first step, really, to look at mutuality of obligation, is answering those 2 questions. So the final pillar then is supervision, direction and control. They are taken as one test when you're looking at it. And basically what you're looking at is who has the right to determine how the work is done, when the work is done, what order it's done in, and whether that individual is supervised by someone at the end user client. So if the end user client has the right to exercise that level of control, to require certain things be done in a certain way at a certain time in a certain order, then again, you're looking at, in old speak, a sort of typical old master and servant relationship. which will lead you towards deemed employment. However, if the individual has a fairly wide discretion to do the work when they want, how they want, then again, that's going to lean you the other way. Now, you'll have heard me when I've been saying that talk about the right to exercise supervision, direction or control. That may still be present even if the end user client never actually exercises their right to do that. So what the tribunal will look at is who has the right to exercise those three things. And that's what's crucial in these cases. So they will look beyond, again, just what's in the contract, what's documented. They will look at the situation on the ground to see, could that end user client determine any one of those three things. So those are the three pillars. Now, there is a school of thought out there that you need all three of those to have a situation where there is deemed employment and you are brought within the scope of the off-payroll working rules. I don't think it's always quite as straightforward as that. And what we would be advising you is to take a balanced view in the round when looking at all of those things and almost apply a sort of scales balancing argument. Which side do the scales, does the evidence point most heavily towards? Now, again, some situations that'll be a fairly straightforward exercise, some it won't be. Now, there are a number of other factors that you can look at when you're making your status determination, which will hopefully help tip it either way in a situation whereby you're not sure. So one of those is how integrated the individual is into the end user client's business. So do they have a pass? Do they have a company email address? Are they invited to the work Christmas party? All of those sorts of things. Do they have access to facilities? The more integrated that person is into the business of the end user, the more likely they are to be in deemed employment. And again, if they are fairly far apart from it and very distinguishable, then you're probably looking more at self-employment. The second thing that you're going to look at is who provides the equipment. So if the individual provides their own equipment, more likely to be self-employed. If the end user provides a lot of the equipment, more likely deemed employment. Similarly, if the end user provides them with a uniform, I think that goes towards integration as well a little bit. But again, the more they are connected with that end user client, the more likely there is to be deemed employment. And the final thing to probably look at is financial risk. So if something goes wrong, who is responsible for putting it right and who bears the financial cost of doing so? If that's the individual, more likely self-employment. If that's the end user, you're more likely looking at a situation of deemed employment. So hopefully those factors, when you look at everything in the round, you should have enough then to make a view on balance as to which side you fall on that scale. So what happens then when you've made that determination? So once you've decided one way or another, you need to put that in writing, and there is an obligation then to send that through the supply chain, as you can see from this diagram. So the end user bears the responsibility for passing it directly to the worker. So as you can see from that diagram on the left, and the arrow on the right hand side shows that the end user must pass the status determination directly to the worker once they have made that. They are also responsible for passing it down the chain. So they have to pass it to the entity that sits below them in the chain, which in that example is that agency. They are then obliged to continue passing it down the chain until it reaches the PSC and the worker. Now, if they fail in their obligations, so you can see there in the example on the right that agency number one has failed to pass on the status determination statement to agency number two. In that situation, agency number one may well find themselves inheriting the fee payer liability for the duration of their non-compliance with that obligation. So it is crucial that you comply with your obligations to pass the information down the chain, or there is a fairly hefty price to pay for failing to comply with that obligation. So just one more thing to note in terms of the status determination statement. The individual has the right to challenge the determination that you make. So they will challenge that in writing to the end user, who then has 45 days to respond to that in writing, setting out the reasons why they are either reaffirming their decision or they're changing their minds. That is essentially the end of that challenge process once the response has been received. So I think it's fairly unlikely that it will have a substantial effect on end users' decisions that they ultimately make. But again, be aware and just make sure that you comply as the end user with those obligations, because, and you'll start to see a theme develop here, if you don't comply with those obligations, you may well be landed with the fee payer liability for the duration of your non-compliance with those obligations. Now, that is obviously a lot to take on, and so there is some help and support available out there. And so I will pass you back over now to Oliver to talk you through the help that can be provided by HMRC's CEST tool.
There is, yeah, there's assistance online in terms of the CEST tool. Probably heard it, you may have used it, you may have looked at it. So it's a really useful tool. So we all say to clients and contacts that come to us about off-payroll workers and IR35 advice is, well, actually, have you looked at the CEST tool? Have you done your own determination? And what do you think about the relationship before we drill down into the answers and information provided? So the CEST tool, so the Check Employment Status for Tax tool, is online. It's on the main government website. So there's not an absolute obligation to do it. So if HMRC look at the relationship or contact you about the chain or information, etc., they don't expect and require you to have used the CEST tool and then provide evidence of that. But it's useful because it gives you a view when you're looking at the employment relationship, if there is a deemed employment relationship, based on the answers that you put into the website. Now, it's been probably quite widely criticised by a number of people, by solicitors, by accountants, by the people that are actually using it, because there isn't much of an emphasis in terms of the questions on the mutuality of obligations that Tom mentioned. So one of the essential pillars that needs to be demonstrated that Tom went through. So really the questions on that area, which you'll see when you do go through and have a play around with it, it's actually quite interesting what information you put in for the results that then come out, is that the questions on that area just aren't clear at all. And it's as if HMRC really think that if there's any type of relationship between the parties, then there's automatically this mutuality of obligations. And that's just not the case, as we know from the employment law tests that you need to go through. But we advise that you use it because the information that you input and the results that you get out are not tracked by HMRC. And they have said, HMRC have said, that they will stand by the results. So if they come to you and you can say, look, I've used the CEST online check, this is the results that I received, then HMRC will stand by the results, albeit there is a heavy caveat. And Tom, if you just bring up the caveat screen, as you'd expect, the disclaimer screen from HMRC, which isn't abundantly clear on my screen. It's a bit blurry, but essentially what that says is that you're under an obligation, if you are going to rely upon that the information that you input is accurate. It has to be honestly answered, it has to be accurate and correct. So if HMRC, when they're actually drilling down into the relationship and looking in reality, how does it work, if they find that some of the information that you put in as an answer isn't accurate, then they will not stand by that. So you may have a liability and it could be evidence as actual non-compliance because you've answered dishonestly. So be careful, but it's worth a play around, have a look, because it does give you some good guidance about whether there is this deemed relationship or not. But what we would say inevitably is always get advice on the situation as well. So speak to us, speak to your accountants. We've been doing plenty of advice on the topic. to just make sure that the information that you've inputted is correct and you're getting the outcome that you want. But we found some clients, or probably people that have contacted us, have said that, well, we've been through the CES tool and we've put in information about 50 times until we get the answer that we want, and that we won't fall within it. But unfortunately, that's not what it's there for, that you can't just keep going until you get the outcome that you want. But we do get people say that, don't we, Tom, quite often, that they've been through it that many times that they've got the outcome that they finally need, shall we say. So with that in mind, really, Tom, what should businesses really be doing now, or probably what should they have been doing pre-April to get ready for the introduction? And now the off-pay worker rules are here for private companies. What should people be looking at and doing, probably really, to protect themselves?
Yeah, absolutely. Like you said, Oliver, these rules have now come in with effect from the 6th of April. So hopefully what this webinar has done is demonstrated to you all that you're doing everything right. You're following all the rules that we've set out, and that you are compliant. But obviously, any arrangements that are caught by the rules, so that have this individual PSC end user relationship, they should be being looked at, and any payments that are made to individuals by the end users as part of those arrangements should now be compliant with the off-payroll working rules. So the fee payer liability should have been properly ascertained. So should it lie with the PSC if it's outside the scope of the rules, or should it lie with any other user in the chain if it is within the scope of the rules? So you really need to be having a look at your working arrangements and seeing whether there are any supply chains like this for a start. And if there are, and you haven't done a status determination yet at this point, then you need to be getting yourself on that CES tool first of all, as Oliver's just outlined, getting a preliminary view as to their employment status for tax, seeing if you agree with that view, taking your own view and having a look at it, because there is an obligation in the actual legislation that you provide an honest assessment in respect of each individual. So what you shouldn't be doing is just relying on a blanket determination that either everyone that you contract with is either in or out of the rules. So you need to be doing this for each individual situation. So get on the CES tool, have a look, see if you can provide a preliminary assessment. If you're happy with it, send it out as a status determination statement, and make sure that from that point forwards that any payments that are made have the correct tax and national insurance deducted from the appropriate party, depending on the outcome that you've looked at. Now, what you might find as a result of undertaking that exercise is that you're not really happy with those working arrangements. You've potentially inherited quite a significant liability for tax and national insurance that you really don't want or can't bear. So it is a good reason to really delve into your working practices and see if there is anything that you want to do differently. So can we structure the working relationship with these individuals differently so that it takes them outside of the rules? So can we relinquish some control? Can we allow them to send in a substitute? Can we remove their obligation to accept work that we put in front of them? Because all of those things will shift the ultimate status determination and move the fee payer liability potentially away from you. So can we restructure those working arrangements? Do we therefore need to amend our contracts that we give out to these types of subcontractors to reflect that new working arrangement and provide further evidence of the structure of the relationship? And we would always say, regardless of the fact that I know I've mentioned on a couple of occasions that tribunals will look beyond the contracts when they're looking at these relationships, we would always advise having a robust contract in place in writing with these individuals. Alternatively, if you don't want to relinquish that level of control, you don't want to let them off the hook for being able to refuse work, well, there are other ways and means of doing that. Can we potentially work more with agencies? Now, you'll have seen from the examples that we've shown you that if you get an agency come in the middle of you and the personal service company, then what you're looking at is they will inherit that fee payer liability rather than you. And so working more with agencies and getting them involved in the middle is perhaps beneficial to yourself. However, a word of potential caution is that they will be acutely aware of these new rules and the impact of them. So there's probably going to be some level of negotiation involved in talking about fees with them where they are inheriting that sort of level of liability. The other option then is, can we bring these people on the books? Do we, just take everything on the chin? We're going to be paying tax and national insurance anyway. I've said or touched on that these tests for tax and employment rights are fairly similar. So do we just want to completely avoid all risk of them deciding that they, well, why are we paying tax as employees if we're not getting all the rights of employees? They might decide then that they want to start trying it on and potentially bringing claims. So by bringing them on the books and giving them all of those rights that they might start asking for, you remove a lot of the risk, but you take on the cost and the burden of the employer obligations that come with that. So there's a lot of different ways and means of trying to sort of maneuver and get these relationships how you want them. And it is far better to do that sooner rather than later. And you can use the introduction of these new rules almost as a bit of an excuse to start to try and deal with these individuals and these contractual relationships moving forwards. And as Oliver has said, this isn't a straightforward area of law. It is potentially quite complicated. And so if you are unsure of your obligations, if you are unsure of the risks and you want to talk that through, then go and get some advice, because it can potentially save you in the long run getting that advice at the early stage before you start taking that level of action. And with that in mind, I just want to talk to you briefly about what we can do to help you with that. So what we have developed is an IR35 advice service where we provide fixed fee support to anyone in those supply chains. So it doesn't have to be an end user client that approaches us. You can approach us as an individual providing services who has a personal service company. And what we will do is provide you with a no obligation fixed fee quote to either review your current existing contracts that you've got in place, or we can produce a template contract for you to use with your subcontractors. We can provide assistance in giving you an indication of what our view would be in terms of someone's status determination. So having a look through all the evidence with you and putting it through the CES tool and coming up with what we think is the correct determination of someone's status. And what we've also found to be quite beneficial, and a number of our existing clients have asked us for, is to produce a template IR35 policy, produce a template status determination statement that they can use. So again, we can provide a fixed fee quote to assist in putting together those sorts of template documents for you to use. And I'll just then briefly hand you back to Oliver to talk about what we can offer more widely as an employment team in terms of our Adapt HR service.
Yeah, just before we get into that, but probably on the IR35 off payroll work front, we've been helping a lot of clients with it throughout, and Tom particularly has been as well. And we've been working with a lot of local accountants as well to look at their clients and contacts and helping them with advice for people on the impact of whether they fall inside or out. I think probably the big concern with the off payroll worker implicate rules coming in was that just the end user client would decide en masse that they would just not engage with contractors or people supplying the services through PSCs anymore, and they'd say, well, we're not going to use you, and your option is that you have to come on the books, as it were, as an employee. But whilst that may have happened in the public sector to an extent back in 2017, when that came in. We've probably not seen it to the same level in the private sector when it came in April this year, that those end user big businesses haven't been saying it's this way now or the highway, and we're not going to use you if you're still going to continue to provide your services through the PSC route. They've actually been applying the test, doing the status determination, and applying it to each relationship that they have, rather than making that decision en masse that it's that way or nothing, really. I've got a couple of questions as well, just before we get to the Adapt HR part, is that Adam asks, could a subcontractor ever be classed as the end user client? Which no, that they couldn't, because remember, the end user client has to be a medium or large entity with a UK connection. And there's those exemptions that Tom went through about the end user client being small, then it will not apply. Tom, these two probably are relevant to the sections that you touched upon. Sarah's got a couple of questions. One, if we pay experts for advice, the odd £25, £50 here and there, should we be concerned with IR35 for these people?
Yeah, well, I think in that circumstance, what you really, you just need to look at whether or not IR35 applies. It will apply to any arrangement regardless of the sums involved. But in terms of any liability that comes along with those little bits and pieces, it's a decision really for the company as to whether they want to engage in the dealing with the IR35 on that basis, or whether they're happy to proceed. But IR35 does technically apply as a matter of law in the situation where you have the supply chains that we've mentioned, and where those small company and UK connection exemptions don't apply. So technically, IR35 could well apply in that situation, and therefore, strictly speaking, those entities should be engaging with it and applying their minds to it. I suspect the likely outcome of that is that those individuals won't be considered to be within the rules, because there won't be deemed employment. And so it would simply be a case of sending them a status determination to say, you're not in deemed employment, and therefore the rules don't apply. And that will really be the extent of the obligation, unless that relationship materially changes. So yeah, strictly speaking, if the rules apply, they apply regardless of the sums involved. But in that sort of situation, I would expect you to be outside the scope of the rules. So any burden on the end user in that situation is likely to be fairly limited.
Yeah, I think probably those words here and there, just now and again, probably reflect that deemed employment wouldn't be established. One question, Tom, that we get asked quite a lot, don't we, as well, if we do use someone fairly regularly through a personal service company to provide the services for us, how often do we have to reevaluate the relationship? So if they come and do something for us for a few weeks, but then there's a big break, do they then have to reevaluate it each time, or can they rely on the initial status check that they did? So what would you advise end users in that situation, Tom?
I think my advice in that situation would be that there is an obligation really to consistently review the position with IR35. And if the relationship materially changes in some way, then you would have to update your status determination to reflect that. And I think it really probably depends on the nature of the relationship and how often they are engaged. If someone is engaged, every 2 or 3 weeks to do a few days here and there, then you wouldn't update it every time you bring them on just for the sake of 2 or 3 days work when they've last been in a few weeks ago. I think you would be fine, unless something has materially changed in the relationship during that period, to simply rely on the previous statements, albeit you may want to just reiterate that to them and say, here's what we sent you previously, this is still the case, just to make sure. But I think where it is more spread out, and potentially there are sort of longer projects that you engage these individuals on. So if you had them on for 4 months last year there was 3 or 4 months break and then you brought them back on again. I think for those sort of longer engagements, more spread apart, then it's probably on a sort of project by project basis that you would be looking to just review. There's no obligation really to go through the whole process again, but it's good to just keep them updated in terms of the individual on the status in that situation. So if you look at the relationship and say, well, you're working on the same contract, nothing's changed from our perspective, as long as you can show that you've applied your mind to it, and I would probably advise that you send them a new status determination statement or send them the original as before and just say, we are continuing to rely on this, then I think that would be fine. Alternatively, if you're engaging them more regularly, what I would probably advise is every 6 months, maybe 12 months at a maximum, that you just sit down and review all the people that you've got that you engage on a regular basis, just to double check the situation and maybe just send a small little note out to those individuals just to say, we've done our 6 monthly review, everything's the same. And that's something that could be built into potentially an IR35 policy, if that is something that you wanted to have, just so that you've got a framework for that. But I think really it depends on the nature of the arrangement, how often they are engaged, what the length of those engagements are. But really the crux of it is, has the relationship changed? If it hasn't, then you should be fine to rely on the previous statement. It's just whether you send them a copy of that and update that and have a written record that you've done that, and how.
Yeah, really you need that material change. That's probably a review and a trigger point for certainly the end user to review that relationship. Absolutely. And the 12-month review is a good idea because it's just, particularly with the end user, it's reviewing if any potential liability may change and increase. So it's useful to include a review period of 12 months just to have a reflection on those relationships. Final question at the minute in terms of the chat, Tom, is how do you actually tell if someone's a personal service company? So in terms of looking at the intermediary, Sarah's asked, so should you actually ask them that question? How do you look into that? What steps should you be taking, Tom, to look at the intermediary and whether it's a personal service company or not?
Yeah, well, certainly I'll be asking the individual that question at the outset before you contract with them. Just ask them outright, do they provide services through a personal service company? Are they the sole director shareholder of that company? Do they have the controlling interest in that? If they're unwilling to provide that information, then I would probably be cautious about contracting with them in the first place. But there are other ways of doing it. So for example, if they give you the name of the company that would ultimately be invoicing you as the end user client, you can perform a company's house search for free on the gov.uk website. And on there, you will be able to find relevant information about that company, most notably who the relevant people are involved in that company and whether or not they have a controlling interest. So there are searches outside of it, but certainly the first step is to ask the individual concerned, and you would hope in most circumstances that they would be willing to supply you with any information that you need in order to comply with your obligations. Sometimes what we do see as well is that within the contract that we put together is an obligation on the individual to provide any information on request that will assist with the company in complying with its IR35 obligations, and potentially an indemnity in respect of any liability if they fail to provide that information. So that's fairly full on and a bit belt and braces perhaps, but it is another way to protect yourself if you are concerned that you haven't been provided with all the information or that you can't find the information. But certainly ask with the individual and check on Companies House or any other sort of company checker search that you are able to access certainly as a first step in ascertaining the information that you need about that intermediary.
Yeah. That's good. That's the end. There's no other questions at the moment in terms of the chat, just conscious of time as well. So I'll very, very briefly mention Adapt HR. So we work with a lot of local businesses to provide employment advice on a regular basis, employment HR advice. And we do that through a service called Adapt HR. So it's a fixed monthly price for unlimited employment HR advice on any issues that you as a business may have. For a period of 12 months. So we will send out some further information on that so that you can have a look at it. But really, thanks for listening. IR35's, it is a complex area. Hopefully we've made it a little bit clearer in terms of the charts, the diagrams as well. Thanks everybody for listening, and thanks to the group, CIPD group, for asking us back to talk. It's great to see you all, albeit virtually, and hopefully we'll actually be able to see you all properly soon, face to face. I'll pass it back over to Sam. Thanks.
Thanks, Oliver. So it's just left up to me on behalf of the committee to thank Oliver and Tom for their presentation today and their time. I think we're all agreed it's quite a complex area of law. So I think, you know, you helping us to understand that is very much appreciated. So thank you on behalf of the committee. Just a reminder about the next event coming up on the 9th of June, which is the AGM and mental health and wellbeing event. So we would like to see as many people there as possible. And thank you very much to everyone for attending this morning. And I hope you have a good rest of the day. Thank you very much.